of what really transpired today, and we are joined by Mr. Mahesh Jethmalani. He needs no introduction. He's a member of Parliament, Rajya Sabha member of Parliament, supported by the Bharatiya Janata Party, member of the party, and also, of course, a noted legal mind in his own right. Mr. Jethmalani, thank you very much for speaking to me. I want to ask you directly, straight, without any of the usual caveats, does this cause lack a strong case, point blank?
Rahul, everything really turned on whether the court held that the right to marriage was a constitutional right. If it was a constitutional right, then, if the court did recognize it to be a constitutional right, that the right to marry flowed from the Constitution, then things would be quite different for the LGBTQ community. They would be on a much better wicket. But, and this was always going to be an issue, if they found, in fact, the minority judgment, Justice Chandrachud and Justice Kaul, they held that it was a civil union, right? The majority judgment held that neither the right to marry nor even the right to enter into a civil union, which is, I suppose, a union akin to marriage, but not exactly marriage, right? Neither of them flowed from the Constitution. Now, that being the case, what they impliedly said, and actually what they explicitly said in parts of the judgment, was that this flows from statute. Your right to marry or your right to enter into a civil union, right, both stem from statute. Absent a statute, right, the courts can't recognize it. It is in the domain of Parliament and the union government. So that's where, that's the point one was looking for in this judgment. If you escalated that right to a constitutional right, then yes, the LGBTQ community would be in business. But having restrained themselves from going that far, right, you are left with a situation where it has gone, and that's probably a right view, that it's gone back to where it always belonged, i.e. to the domain of the legislature and the executive. And they will have to now legislate. The good thing for the LGBTQ community is that, and not transgenders, because transgenders have a right to marry already, but the other categories, the good thing for them is that the Supreme Court, the majority judgment, has asked for a high-powered committee headed by the Cabinet Secretary to go into all issues as expeditiously as possible concerning same-sex marriage. So to expedite them, and if they can be brought on par, really, some way or the other. Because the existing statutes on marriage, the Special Marriage Act, the Hindu Marriage Act, all the, religious acts, none of them allow any construction for same-sex marriages. They're very clear in their definition of who is capable of undergoing the ceremonies requisite for a marriage. And unfortunately, people belong to the same sex do not come within the language. You'd be torturing the language of those statutes.
Of course, I'll come to the Parliament's role in just a few moments, but I want to ask you, because this was raised in court also by the AG and the ASG. They said that, look, the Supreme Court shouldn't have even gone into this matter in the first place. Do you think, in hindsight, the Supreme Court could have well steered clear of this?
Well, Rahul, the fact of the matter is, we are trying. This is the age of inclusion, right? So the Supreme Court felt that there was a and as Justice Chandrachud pointed out in his judgment, this is not just an urban phenomenon. It's not an elitist, category of people. So it's quite widespread. And we want to include them if possible. So if they were examining it, there was a petition before them, they had to deal with it. Right? They can't say, without looking into it, right? It's not that, the law is somehow or the other buried in their chest that they have to spill it out, right? They have to hear parties, hear the rival contentions, right? And ultimately, after a searching examination of the whole issue, right, they came to this conclusion, which they finally did. And there were split verdicts. One was slightly more liberal in the sense that they said at least civil unions are permissible. The other was, a strict constructionist view that any kind of relationship requires statutory intervention. That's how it broke up, really. So you can't blame the Supreme Court. To answer your question, it would be extremely unfair to blame the Supreme Court for taking up the issue.
Okay, so let me then extend that logic, because what has actually resulted from all of this is that the Supreme Court has upheld the principle that the majority therefore must decide. It's given the baton now, passed it to Parliament. And if it is the age of inclusion, why won't Parliament then do what is expected of it, which is grant these people their dignity, their rights? Has the time come?
Look, if I give you an answer right now, it will be a prescriptive answer. It will be my own personal view, right? So, Parliament, when it passes legislation, right, and it's really, far-reaching legislation, which is a clear break from the past, requires to hear all stakeholders, not just those who will benefit from this legislation, but also, stakeholders who have an interest, sometimes a vested interest, religious community. I mean, for instance, the Muslim community, the All India Muslim Personal Law Board was dead against, extending these rights. So they have to be heard. Every stakeholder has to be heard in this matter, and that's what Parliament will do now. They've heard the request of the Supreme Court, set up a high-level committee, and they will expeditiously be calling all stakeholders to see whether it redounds to justice, fairness, etc. Right? But before they have to give natural justice to those opposed to this issue as well.
Obviously that is the way things work in Parliament. But fundamentally, Mr. Jethmalani, one of the reasons why a large number of those who stand on the side of inclusion are feeling a bit despondent today is because the government of the day, which is in the majority, has already taken a stand against this issue very clearly in court, number one. Number two, the fact is that Parliament has never or has seldom stood, there are a few examples, seldom stood really, as a champions of progressivism, societal progressivism. I mean, you've had the Shah Bano example, and we see how the Parliament tied itself up, or that government of the day tied itself up in knots. So clearly this is now, the door is shut really, isn't it?
No, the door is not shut at all. I'm sorry, the door is not shut, Rahul. I mean, there's plenty of hope. Let's see what the high-level committee says, what the recommendations are, right? So we have. I mean, I don't see that being shut at all. I just see it not being rushed through. That's all. I would say that the way to interpret today's outcome is to say that the Supreme Court has wisely and rightly eschewed jurisdiction because it rightly found that it had none, right? So it has eschewed jurisdiction. It has not pervaded. I mean, we often complain that, the Supreme Court is trespassing into the domain of the legislature, right?
Yeah.
Now, today when they eschew it, right, you can't blame them. They found that this is a matter for weighty construction by those who are endowed by the Constitution with the power to legislate.
Thank you, Mr. Jethmalani.
And they will do it in their own manner.
Okay, thank you very much. I think you put your point across. Let's open this up for further and wider debate. Thank you very much. That was Mr. Jethmalani joining us live there.